practice in economic sanctions law in the very crazy year of 2022. I'm grateful to Benji and the other people in society and Scoop for letting us have this event, and I think it's going to be a very interesting discussion. We are very fortunate to have three experts on economic sanctions law, all of whom are willing to fly down from Washington to be with us today. I'm going to introduce them all, and again, with thanks and appreciation. First, immediately on my left is Nedi Mfudu-Nweke. She is a partner at the Gump Law Firm. She counsels clients on U.S. laws and policy affecting cross-border transactions, including export controls, economic sanctions, trade embargoes, anti-corruption laws, anti-boycott laws, and anti-money laundering laws. She also serves on the board of the Center for Democracy in the Americas, which is a DC-based non-profit, nonpartisan organization that promotes U.S. policy towards the Americas based on engagement and mutual respect. Next, we have Nicole Erb. She's a partner at White & Case. She co-leads the firm's economic sanctions practice and serves on the firm's Global Partnership Committee. Nicole works on a variety of sanctions matters and also practices complex transnational litigation and civil and criminal government investigations. And then at the far side of the table, we have Eric Ferrari. Eric is the founder and principal of Ferrari & Associates, a boutique law firm in Washington that represents clients around the world in a variety of OFAC-related matters. These matters include advice on compliance with sanctions, licensing, defending subjects of OFAC enforcement proceedings, and challenging OFAC actions in court. His experience includes numerous lawsuits against OFAC and related appeals. Like I said, this is a very interesting year for sanctions, most of all because of the really unprecedented series of actions concerning Russia. And so we're hoping to get into some good discussions. It's not an academic thing. There's no PowerPoint, and there's no speeches. We're just going to have a discussion among lawyers practicing in the field. And it's really, I've been doing this now for 29 years, and I have to say there's been no year like this year, and I'm hoping that our colleagues can bring out some of what's interesting about it. But just to lay a little bit of groundwork for those of you who are new to the field, we're going to begin by having the colleagues introduce some of the key aspects of sanctions. And I realize I've already used some acronyms, and I'm hoping maybe just to enlighten people who don't know what is OFAC and what is the SDN list and things like that we'll be talking about.
Excuse me. Thank you, Perry. Can you hear me okay? Okay, perfect. So my name is Nedi Mfudu, as Perry said, and I've been practicing in the sanctions space for about 15 years now, and I'm based in Washington, D.C. So sanctions, I think, if you hadn't heard of them prior to this year, you probably have. It's the principal tool that the U.S. and its allies have been deploying with respect to the ongoing Russian invasion of Ukraine, beyond sort of sending certain defense equipment. But sanctions are essentially a tool, a foreign policy tool, right? It's often deployed in lieu of putting boots on the ground, right? We can't fight every war, but we use sanctions often as a way to change behavior, to typically, I guess, as a carrot as a stick, to encourage countries, territories, entities, individuals to change behavior, or preemptively not to engage in certain behavior. The principal agency in the U.S. that administers and enforces sanctions, a small agency at the U.S. Department of the Treasury called the Office of Foreign Assets Control, also known as OFAC. And it is supported in this role in some degree by the State Department, which provides policy guidance on sanctions matters. And also, Increasingly, the State Department is also imposing sanctions. And generally, OFAC administers two main types, or maybe three main types of sanctions programs. You have comprehensive sanctions, which is sort of a comprehensive embargo. Think a total restriction on dealing with certain countries with very limited exceptions. So, for example, we have Iran, Cuba, Syria, North Korea. These are all countries that are subject to comprehensive embargoes, right? Most transactions involving these countries are prohibited, and we now also have more recently comprehensive sanctions on particular regions. Think Ukraine, right? So we have comprehensive sanctions in place against Crimea, the Luhansk and Donetsk republics of Ukraine. And then we have list-based sanctions, where we designate particular individuals or entities, famously on what is known as a specially designated nationals list, the SDN list. So if you're designated on the SDN list, that means that U.S. persons generally can't engage in any business with you, save for limited exceptions. And any restrictions that apply to persons or entities on the SDN list also flow down to any entities that they own 50% or more than 50%. That's just a brief overview of the landscape of what are sanctions, who are the primary administrators of sanctions in the U.S.
Well, thanks, Mehdi, appreciate it. And next, Eric, you were going to tell us a little bit about where OFAC gets its legal authority to do this from.
Sure. So I'm primarily going to discuss the main statutory authority OFAC relies upon, which is the International Emergency Economic Powers Act, IEPA. So we'll probably throw that term around a few times today, but IEPA is what is invoked by the president in many cases to impose sanctions. And what's interesting about IEPA is that it was enacted in 1977 actually to rein in the executive's sanctions powers as previously exercised under the Trading with the Enemy Act of 1917. There was a sense from Congress that the powers were being used a bit too broadly and were a bit too broad. That prior authority, the Trading with the Enemy Act, TWIA, blocked entire countries and nationals, and therefore forbade U.S. persons from dealing with those countries and its nationals, even when those nationals were located outside of that particular jurisdiction. It didn't have the same sort of procedural limitations that we see in IEPA. And what are those limitations? Well, to invoke the authority under IEPA, the president has to declare a national emergency. That some threat arising in whole or in part outside of the United States exists to the U.S. national security, foreign policy, or economy. And when the president declares that national emergency under the National Emergencies Act, that he or she can use their powers under IEPA to engage in a variety of regulations of trade and economic activity, but what we commonly think of as imposed economic sanctions. These national emergencies are to be renewed once per year, so it was thought that by having the president use this authority as opposed to TWIA, that Congress would have a little bit more oversight over the exercise of sanctions authorities than existed under TWIA. We'll get back to that in a moment. IEPA also had a number of exemptions to it that didn't exist under the sanctions programs promulgated pursuant to the TWIA authority. So that was a change as well. There's been extensive use of this authority and some significant amendments over the years. Additional categories of activities have been carved out from the president's authority under IEPA. There's also been changes to the penalty provision, which some have argued, and I would argue, actually expanded the jurisdictional reach of the statute. So there have been some developments, but this has been the primary tool since the late 70s for the president when imposing economic sanctions. And just so you understand kind of the life cycle of a sanctions program, what you have is you have this declaration of a national emergency, you have the invocation of the authority under IEPA, you have the issuance of an executive order, which sets out certain prohibitions with respect to various categories of activity or sets forth criteria upon which sanctions can be imposed upon persons engaged in whatever activity is deemed contrary to the aims and giving rise to the threat declared by that national emergency. And then from there, the Secretary of the Treasury, through delegation to OFAC, will impose regulations that kind of set forth in the sanctions program as you see it when it's codified into regulation. One of the things that I think is important to note, however, and this has become particularly relevant in recent years, is IEEPA is not the only sanction statute. There are a lot of other sanction statutes now. Congress has really attempted to throw their weight around in the sanction space, and so you'll see other statutes invoked in these executive orders as well. And while that's interesting or perhaps notable, you'll always, not always, but in most cases, you'll see IEEPA as the primary authority giving rise to the particular executive order for which sanctions are being imposed. The reason I bring that up and why it's relevant is because remember what I said earlier is that IEEPA was originally intended to rein in executive power, but in recent cases we've seen it's actually been used to expand executive power. And let me give you a prime example. There's an executive order, and I'm not going to get too much into the weeds here, but there's an executive order, 13818, which is commonly referred to as the Global Magnitsky Sanctions Executive Order. Okay, so this targets corruption-related activities worldwide as well as human rights abuses. Well, so Congress put out a law, or passed a law, and a law was enacted, the Global Magnitsky Anti-Corruption Human Rights Accountability Act. And in that act, there was a provision which dealt with termination of sanctions imposed under that authority. So, when the President issued Executive Order 13818, they invoked both IEEPA as well as the Global Magnitsky Act. So you would think that the termination criteria that Congress set forth for when terminating sanctions on a person designated under that authority would be captured when administering the sanctions program. Well, it wasn't, because what OFAC has said in recent guidance that I'm aware of is that it doesn't matter what if the termination criteria of the Global Magnitsky Act is satisfied, because IEEPA doesn't contain that termination criteria, and therefore it's irrelevant for purposes of administering Executive Order 13818. So, just to bring it full circle, IEEPA is the primary sanction statute, originally passed so that we could rein in executive power, but it's now being used actually to expand executive power and to evade congressional will. One other example of that is going back to this reporting requirement on the declaration of national emergencies. So the President declares a national emergency, and then every year that national emergency has to be renewed. Anyone who's followed this knows that we've had a national emergency in place on a variety of activities and on a number of countries for decades and decades. And this reporting requirement has become less of a limitation on executive power and more of a pro forma exercise. Now, if you look at the reports that are submitted to Congress, they're pretty plain. They're just stating that these certain activities that gave rise to the national emergency still exist, and therefore the national emergency has to continue on. We of course don't get to see what's in the classified reporting, but it seems that IEEPA, once intended to limit executive power, has only actually expanded it, and that's pretty evident just from the fact that sanctions are ever increasingly frequently used and in more aggressive ways. So I know that was a lot. I'll stop there.
Thanks, Eric. Well, your closing point is actually a good segue into Nicole's comments, which we're going to talk about one particular statute that Congress has enacted that's particularly relevant today.
So you flipped the order on us, but it was actually going to be me doing the first one, but I'm happy to talk a little bit about CATSA. No, it's fine. So CATSA is a statute, and let me just pick up actually on something that, Eric, you said, which I think is relevant to CATSA and also relevant to what's happening with respect to Russia right now. So there is a we talked about the State Department and OFAC, and there are negotiations that happen interagency, even within state and OFAC, on sanctions implementation and sanctions policy. And then we have Congress and the executive. And there it's really a battle. It's a friendly battle sometimes, but it's a battle over who's going to have the most control over this space. And what we see on the executive side is exactly what Eric is describing under the authority of IEPA and many other statutes. The president will issue an executive order, and that executive order can be retracted very quickly and very easily. A very nimble tool for foreign policy. Sanctions can be imposed and withdrawn very quickly. When you're talking about legislation, it's much harder. And what we see in the case of Cuba, for example, when you have congressional legislation, it makes it very difficult for the president to use his executive or her executive power to lift sanctions that are established by way of legislation. So with Cuba, there's only been so much various presidents can do with respect to the Cuba emergency because of the legislation that's on the books. When we talk about CAATSA was enacted in connection with the annexation of Crimea and imposed, helped impose the first round of sanctions that we saw targeting Russia and Russian aggression over the period beginning around 2014 and then in 2017. And CAATSA is playing much less of a role in this round of sanctions. And in fact, the executive has gone as far as to issue an FAQ that would, basically says that the rules that would apply to CAATSA to blocked persons under the old sanctions from 2014, where CAATSA's rules would trigger, those rules don't apply for entities that are only designated under the new authorities that are at play with respect to the sanctions right now. So it's interesting to see this kind of turf war play out in the regulations and in the legislation. With respect to the types of sanctions we're seeing, what I wanted to talk about was the types of sanctions we see with respect to the current situation with Russia. And I think most of them draw exactly on the tools, and I'm calling them tools because I think that's what they are, that we discussed, that the blocking rules and then other rules that OFAC has the power to implement. But I want to go into a little bit more detail with some of them. So we talked about blocking and less than blocking listing sanctions. So these are sanctions that the U.S. government puts out a list, the 50% rule applies, and the individuals and entities on that list are subject to different restrictions, and U.S. persons can do certain things with those parties or not do certain things with those parties. The most common is what we refer to as the SDN list. It's full blocking. Any assets of that entity or individual in the United States or in the possession or control of a U.S. person is blocked, and U.S. persons can't deal with that entity or any of their entities that are 50% or greater owned. This has been, when we saw in March, February and March, this was a dominant tool in the latest round of sanctions, right? The United States imposed blocking sanctions against major Russian banks. This was a huge deal. And they stopped short with certain of them, right? Gazprom Bank, they stopped short. Sberbank, even, they stopped short. Sberbank, at the beginning of this conflict, was only subject to restrictions on the type of bank accounts it could have in the United States. So its correspondent banking rights were impinged upon. It wasn't blocked at the beginning. I think it was blocked in April. Yeah. So that changed. So what we're seeing with this latest round is incremental increases on the types of restrictions that the U.S. has imposed. So we start with blocking some banks. That expands to more banks. We've seen encroachments. The biggest one, I think, that we're all, as practitioners, at least I am dealing with on a daily basis, is the new investment ban and the scope of the new investment ban. The U.S. has basically said that U.S. persons cannot engage in and cannot facilitate any new investment in Russia. That is huge. And that means by facilitate, what's captured in that is U.S. banks processing U.S. dollar transactions. So what does that actually mean? OFAC has tried to provide guidance on what new investment is and what it is not, right? It is a commitment of capital where there's a return expected. It is not ordinary commercial dealings for the sale of goods and services. There's a lot of space in between those, right, that becomes subject to interpretation. My favorite is that OFAC has restricted investment in non-Russian entities that derive a predominant amount of their revenue from their Russian investments. So that determination is pretty hard to do when you don't have a definition of what predominant is, and you don't know what investments, that company's investments in Russia include. Does that mean all of its operations in Russia? So are we looking at revenues derived from all of the operations of that entity in Russia, or just revenues derived from that entity's investments in Russia, and what does that mean? So these are the types of granular points of decision that, as practitioners, we are making on a daily basis. Another area that I think is pretty novel, the way OFAC is approaching it, is with this latest round of sanctions, is the services restriction. So OFAC, together with its allies, has banned the provision of trust and corporate formation services, accounting services, management consulting services, directly or indirectly to Russia. Again, U.S. persons cannot engage in that activity and cannot facilitate it. So no indirect support by a U.S. person. And that services prohibition is authorized pursuant to an executive order where the executive will make a determination as to a certain category of services. And we're now seeing that invoked in connection with the price cap that is getting a lot of discussion right now, and the services that are going to be restricted in connection with the price cap. So I could go on. There's a lot of different types of sanctions that are in play here. We didn't even get to the new debt and new equity sanctions that are still very relevant. Those are holdovers from 2014 that largely apply. Probably the biggest player there is Gazprom, is designated under Directive 3 or listed under Directive 3. And that means that only certain types of financing is available for Gazprom. There's only it's trying to restrict access to the capital markets to entities that are subject to those new debt and equity restrictions, and that's sort of a less than blocking restriction. So the rules that we can talk about sanctions as a policy tool, but when you get into the specific rules, especially when we look at what's happening with this latest wave of Russia sanctions, is really the devil is in the details. It's all fact-driven. And we haven't even started talking about that we have to balance this against what the EU is doing, and the UK and Canada and Switzerland, et cetera. So let me pause there.
Well, I think, thank you, Nicole. I think that Nicole's conversation has really taken us into right up to 2022, and the question of how is this year different from other years that you've had practicing in this field? What new things are you seeing? What is it like to be a lawyer living through this in 2022? And maybe we'll start with Nettie and just go down the line and see what you want to add to that.
Yeah, I think, what's different about 2022 is Russia, right? It's exactly what Nicole has started discussing. This is the first time that the U.S. has imposed sanctions on a G20 economy. It's not Iran or Cuba, which are pretty small economies. And certainly I don't mean to suggest that we've imposed a comprehensive embargo with respect to Russia. We haven't. But we have imposed broad sanctions. We've targeted particular sectors, we've targeted professional services. The sanctions are not limited to particular individuals or entities, but they certainly affect large sectors of Russian economy. And we're not stopping, right? Just yesterday, I think we've added the provision of quantum computing services, right? So beginning next month, U.S. persons will no longer be able to provide quantum computing services to Russia. And you can expect that as long as the war is ongoing, the U.S. and its allies will continue to impose sanctions on Russia. And I think that what is certainly we have seen periods where the U.S. and the EU have been somewhat aligned in imposing sanctions. We saw this, I think, with Iran prior to the JCPOA, where there was some alignment, not completely, between the U.S. and the EU in imposing sanctions vis-a-vis Iran. But in 2022, the level of coordination was at a level that, for me, is unprecedented in my years of practice, with the U.S., EU, UK being very coordinated in the sanctions against the banks, in the sanctions against high-profile Russian business persons, in the this is largely a European move, but with the removal of certain Russian companies banks from the SWIFT system, even with the restrictions on the importation of certain Russian petroleum products, right? The U.S. was leading in that, but we've certainly seen the UK and the EU come around. So it's been historic on many levels. Switzerland, which is typically, wants to be neutral, even the Swiss have imposed their sanctions. And so if you're a global company having to, and you have a presence in Russia, right? You're one of the few who have not been able to pull out, and maybe you suspended or reduced your operations, but you're still there. And you have a presence in the US, you have a presence in the UK, you have a presence in Canada. You are not only having to comply with all of these sanctions, you're also having to deal with the Russia counter-sanctions measures, right? So Russia has said, we're not just going to sit here and take it, right? We're going to impose our counter-sanctions, which we're going to try to dull or mitigate the effect of these sanctions that you're throwing our way. We're going to limit your ability to move your dollars or your euros outside of Russia. We're going to make it difficult for you to shut down your operations in Russia. And so it's been, if you're a sanctions lawyer in 2022, you've been busy. You've been busy since February. Maybe you're catching your breath now, but it's been an exciting time, I will say, to be a sanctions lawyer. It's unfortunate that there's a backdrop of a war and people are losing their lives, but in terms of the complex sanctions that have been imposed and sort of getting our heads around the new tools and that are being deployed, it's been very interesting.
And I would echo that. I completely agree with Nettie that the extent of the multilateral effort is pretty unprecedented. We did see alignment with the EU and the US in 2014 and with the annexation of Crimea. And the sanctions there were much more limited in scope. So much more limited. And they were pretty intense when they came out, right? And navigating them and the compliance burden associated with them was really very high. But what we're finding is, yes, now the governments are aligned, and in broad strokes, the sanctions are the same across the different jurisdictions. But when you get into the details, there are differences, right? And those differences make engaging in commerce as a market actor, trying to exit Russia as a market actor, very difficult. And what's pretty new for me is I'm very used to my European sanctions colleagues saying, well, it's going to come down to the U.S. It's going to come down to the U.S., right?
Yeah.
What is the U.S. rule? We'll piggyback on what the U.S. rule is because ours are much more relaxed. More and more, companies are unable to do a certain type of business or engage in a particular transaction because of a UK rule, a party that's on the UK asset freeze list that isn't designated in the US, or an EU rule that is not implemented in the same way in the US. Even the 50% rule, which the US has, that is not the same in the EU, and it's again not the same in the UK. I think that the EU aggregates the interests, whereas the UK does not aggregate the interests. In the US, we aggregate the interests. So just calculating, and there's the control issue, right? So in the EU and UK, it's not just an ownership rule. In the US, it's pretty black and white. It's 50% or greater, individually or in the aggregate, right, by one or more block persons. In the EU and UK, as Perry's saying, there's an ownership component and there's also a control component. So if somebody owns 49% and they're a blocked person in the US, that entity you can deal with that entity in the US. In the UK, it's going to depend whether that individual who has the 49% interest, or the entity that has the 49% interest, exercises control over the company. So in analyzing a particular transaction, these are the kinds of nitty-gritty details that you get into. It's like, what's the ownership and under which regime? Is it the US and the UK? And this comes down to the new investment ban. There's investment restrictions coming out of Europe as well and out of the UK as well. They're different than ours. And so in principle and in broad strokes, we're all doing the same thing. But in the minutia, it's quite different. And it makes the compliance burden on market actors just extraordinary. The amount of resources that even OFAC has told us that they've brought in surge resources to deal with this crisis. And in fairness, we've been able to get pretty quick license turnaround out of OFAC, maybe in part due to their surge resources and maybe in part because some of these things are really emergent and they need immediate attention. But so it's just the whole compliance infrastructure that goes with this has really been something unprecedented for us and for the clients and for the agencies themselves.
So yeah, I'll third all of that because all of that's accurate. It's just been so fast paced this year, and I used to write a blog on sanctions law, and I used to keep up with it daily, and then Russia happened, and so I haven't written on that blog, and I don't think in 2022, to be honest. Just there is no time, and it used to be the case where if a general license was issued by OFAC at 9 a.m. in the morning, by noon I'd be able to tell you every word of that general license and what it resolves and where the gaps are. And now if a general license comes out on Monday, you ask me on Friday, I probably haven't even read the general license yet. It's just been that level and frequency of change in the space, and it is all to Russia. So I've experienced everything that my co-panelists have just covered as well. And I would also offer another different angle as to what's different. The State Department has become a lot more involved in this process. Now, the State Department has authority under Executive Order 14024, and that's the primary Russia-related executive order that's been used this year to impose designations. And they've traditionally had authority under a variety of other executive orders to do that as well. What's different this year, though, because our practice is heavily focused on challenging OFAC designation actions, is that state is also administering the review or delisting process for those people or companies that it itself has designated. And so what's interesting about that is you have the State Department, as specifically the Office of Sanctions Implementation and Policy, administering a Treasury regulation. And so there's some interesting delegation issues there, in particular because it's my recollection that the delegation language of the relevant executive order allows the Secretary of the Treasury to delegate to agencies within Treasury, but not within agencies within the U.S. government more broadly. So it's an interesting legal issue, and it's been different interacting with the State Department on these cases than with OFAC. OFAC, as you can imagine, is in the Treasury Department. There are a lot more ones and zeros, X's and O's, so to speak, and the State Department has more policy considerations in mind. And so when we're going through this process to challenge a designation, the questions we've gotten from the State Department are a lot more with respect to how a sanctions removal would look from an optics perspective or from a policy perspective. We've gotten questions like, please provide any public renouncements of Vladimir Putin by your clients, which is a question OFAC would never ask us, and which is really irrelevant to the designation criteria of the order, but is something that the State Department has deemed relevant to whether or not they're going to delist parties. So it's not just the law that is coming up at us fast and heavy. It's also the considerations behind how the law is being administered and implemented. And we've seen the State Department be very aggressive in exercising its designation authority under that order as well. When you look at the designation actions that have come out under Executive Order 14024, a lot of the companies that you see are designated by Treasury, but a lot of the individuals are actually being designated by the State Department. In particular, individuals who are designated for being senior executives, officials, board members of financial institutions in Russia. And so I can tell you from personal knowledge that there are certain of the people they were designated had resigned in protest at the outbreak of the conflict in Ukraine in February, and then 2 months later found themselves on a sanctions list because at the time they were happened to be on the board of the bank. And just going back to this administration question, we've not seen any of those State Department designees be removed, but we have seen some of the OFAC targets be removed, particularly subsidiary financial institutions of those Russian banks that were designated in record time, I might add. As someone who does this a lot and is constantly griping about how slow OFAC is, there was a bank in Russia, Ozon Bank, it was removed after 35 days. It's because OFAC clearly made a mistake. Actually, Ozon Bank reported what that mistake was in their SEC filing. That's why we're aware of it. But also, I think it was a Sberbank or an Alpha Bank subsidiary was removed in about 96 days. There was another subsidiary of one of those banks that was removed in about 100 days. That is lightning fast in the delisting context. I tell clients who have great facts and are willing to do all the right things that they need to be ready to wait at least a year before we gain any traction. So those times are really fast. Then on the State Department side, we're presenting designees who didn't meet the designation criteria to begin with, and we're getting these kind of pronouncement questions. So it's been interesting. It's a different environment, and I'll just make one more point because I think it's up and coming and it's going to be relevant. There was a bill that was introduced recently, which I don't know much about bills getting passed and the likelihood of that thing, but everyone I've talked to thinks it's a surefire thing, where it's going to name a number of other Russian business elites that should be sanctioned. And this is very similar to what happened under the CATSA statute that Nicole was talking about, where you had Section 241, what they called the Kremlin list, which identified significant political figures and what Congress referred to as oligarchs in a report that was published. No legal consequences from the report, just put out a report of those people pursuant to the statute, which Treasury did, and later on you had some designations of those individuals. Why is that? Who cares about that? Here's why it's important, because financial institutions around the world, not just U.S. financial institutions, they don't care about foreign policy, they care about risk policy, so they see a Russian business elite's name come up in a report, even though there's no legal consequence, they adjust their risk appetite towards that person and their companies accordingly. And so it sows additional chaos, and we start getting questions back about, well, is this person sanctioned? No, they're not, but they're in this report. I know, but it doesn't have legal consequences. Could they be sanctioned? It's possible. Okay, we're not going to deal with them. So that's another kind of circumstance we're seeing in the current environment, and it again speaks to what I was talking about earlier, which is Congress really becoming more aggressive and trying to throw their weight around more in the sanctions sphere.
Thank you, Eric. And I think Eric has now led us into a discussion of another important trend in recent sanctions practice, which is the role of other agencies. Besides, OFAC has traditionally had the lead, and the State Department has provided policy guidance, usually in the background. But we're seeing more role, and I think more important and aggressive role by other agencies now. And I'm wondering, Nettie and Nicole, if you want to talk about any trends that you see there, particularly about the Commerce Department and what it's up to.
Yeah, so The Commerce Department, and in particular the Bureau for Industry and Security, also known as BIS, historically, and not just historically, its primary role is the enforcement and administration of the Export Administration Regulations, which is a set of laws or regulations that govern the movement of commodities, so goods, technology, software of U.S. origin or otherwise subject to the Export Administration Regulations. And so the movement of those items outside the U.S. or to non-U.S. persons, right? So they generally administer export control laws and regulations. And they also have, similar to OFAC, they maintain lists of restricted persons and entities. Generally, these are not thought of as sanctions lists per se. They tend to be lists of persons who the Bureau of Industry and Security has determined should not have access to U.S. origin items or items otherwise subject to U.S. export controls because they are there is a risk that they could perhaps use these items in ways that are inconsistent with U.S. national security, or they could be a diversion risk, right? There's a risk that they could divert U.S. origin technology to Iran or other actors that we would rather not have our sensitive technology or software, whatever have you. But increasingly, we've seen the Commerce Department also playing a role in the sanctions space. Notably, during the Trump administration, there was a lot of focus, and there continues to be, on forced labor issues in the Xinjiang region in China. And there was discussion of adding certain Chinese entities to the SDN list as a result of the alleged involvement in forced labor practices. And that didn't happen. Mnuchin at the time thought we're not going to use the SDN list for this. And what ended up happening is that we had a number of Chinese entities added to the BIS entity list, which is, again, a list of companies for which an export license is required in order to send them really any item subject to U.S. export controls, right? And subject to a policy of denial, right? If you want to send them anyone on the entity list, any item subject to the Export Administration Regulations, which is really any item currently in the U.S., right? You would need to apply for a license, and that application would likely be denied. And so instead of sanctioning these individuals, or entities rather, instead of adding them to the SDN list, what ended up happening is they were added to the entity list, which that is not the typical use of the entity list. The entity list is typically used, again, for persons who we believe have exhibited some action that suggests that they present a risk in terms of export control issues, right? There's a risk that they could use an item in a way that we would rather they not, or there's a risk that they could send the item to a bad actor. But these Chinese entities were not presenting that kind of export controls risk. But because OFAC refused to add them to the SDN list, and Wilbur Ross was running the Commerce Department in a way that was perhaps a little unorthodox, those entities instead found themselves on the entity list. And so we sort of saw commerce sort of stepping into a role that is not typical for the Commerce Department.
What I've experienced with the increase in the export control area is BIS has been as active, almost maybe as active as OFAC in the current Russia situation, and has promulgated a number of waves of new export control rules. I'm not an export control practitioner, so I'm not going to go into those. But what I do see when I'm advising clients that are trying to exit Russia, for example, is these export controls can create obstacles to their exit strategy. And it's very complicated because the rules on what can be left behind in Russia and how those items that may be controlled from U.S. purposes, how those items fall into the hands of others in Russia, that is all subject to U.S. export controls, which now restrict the intra-country transfer of items. So from an exit strategy perspective, if you're trying to sell your business or get rid of your business, you are subject to the U.S. export controls with respect to just even just your office, your laptops, your everyday equipment. So it creates this whole other compliance level of trying to do this correctly under U.S. law. And then Nettie mentioned the countermeasures. One thing that I would add is very different in this year is that the countermeasures, which we've seen before out of Canada and Europe, by the way, these kind of have teeth. And normally when a market actor is debating, well, am I going to violate U.S. sanctions or am I going to violate the European blocking statute? I'm going to err on violating the European blocking statute and finding a way around my contractual language to comply with that because I don't want to risk an enforcement action in the United States. Now when you've got people on the ground in Russia trying to figure out are they going to comply with U.S. sanctions and export controls or are they going to face potential consequences in Russia under Russian countermeasures, that debate is not so straightforward, right? Because Russia is seizing, is imprisoning people. There is laws on the books where very basic things could put somebody in prison for a number of years. This is all being debated right now. I think that one may still be subject to further passage in Russia, but so the calculus is just very different in how you exit and how you protect your people. And the export controls have played a big role in that, where there's been need to go in for multiple licenses from the U.S. to allow a U.S. company to exit strategically and carefully.
I'm actually going to punt on export controls because I leave all of that to Keon Meshkat in our office. So, nothing to add there.
I would just add, during the Trump administration, the Defense Department was brought in with regard to China in terms of adding people to the SDN list in a non-conventional role along the lines of what we're hearing. And it seems the Biden administration has ended that experiment. And I think it's fair to say that managing that kind of administrative process is just not something that the Pentagon is used to doing. We've talked a lot about Russia, but it's not the only thing, or at least it doesn't exist entirely on its own, and sanctions against Russia have implications for sanctions against all the other countries that we have sanctions with. So I'm curious if you guys want to talk about what else you've seen that's interesting this year going on in some of the other countries that we have programs against, or the list-based programs, if you prefer.
Well, I can start, but we've. Nothing matches the pace, right, that we've seen with Russia, but there have been, and it didn't start in 2022. I want to say, really, in 2020, we saw the first set of real meaningful sanctions imposed against Russia. So, harking back to what you said about the defense sector getting involved in sanctions. So we had it's the Communist Chinese military companies sanctions, which is now the Communist Chinese industrial complex sanctions under the Biden administration. And so for the first time we saw a sanctions program that was China focused, right, where U.S. persons are prohibited from buying or selling publicly traded securities of particular Chinese companies. And these are companies that are thought to be instrumental in the defense sector in China, right? So thus far, our sanctions with respect to China have been focused on particular issues: defense, forced labor, and more recently, illicit trafficking of drugs, right? Fentanyl, That has resulted in a couple of designations of Chinese persons and entities. And, more recently, the president has said if China continues to display aggression with respect to Taiwan, there could be sanctions. It's not clear in what form these sanctions would appear, but I imagine they would be targeted to particular sectors in China, especially those sectors that may be likely to be involved in any eventual, but hopefully doesn't come to that, but any potential aggression with respect to Taiwan, we may see additional sanctions. And what else? I mean, we've seen some lifting of sanctions with respect to Cuba, but none of the actions in my mind have been as significant as what we saw during the Obama administration, right? So we've seen the lifting of caps on family remittances. We are now issuing visas again in Cuba. We're allowing more travel, but I think that Cuba watchers and people who are pro engagement with Cuba, like myself, we were hoping for, and still hoping for, more decisive easing of sanctions with respect to Cuba.
One area that I find particularly notable, and this, Perry mentioned that I work in transnational litigation and do a lot of foreign sovereign representation and representing state-owned entities that get embroiled in U.S. court litigation, and often our cases intersect with sanctions issues. And as we talk about sanctions as a tool to curb behavior and blocking sanctions in particular, putting bad actors on a list, the blocking sanctions also serve another role in U.S. foreign policy, which is to protect assets. And something we've seen this year, I think the biggest example that we've seen of this is with respect to the Central Bank of Afghanistan funds and what the Biden administration has done with those funds. But even very recently in one of our litigations, the United States filed a brief where they mentioned, this was in connection with Venezuela, and they spoke about sanctions. There's a protective aspect of sanctions, and if blocked assets that are blocked under sanctions, if those assets are available to plaintiffs in litigation, that decreases the U.S.'s leverage and negotiating ability in resolving international emergencies to bring bad actors into what the U.S. would see as more positive behavior and affecting behavior change among states. So it is a very interesting aspect of the sanctions world, because I think we're used to talking about sanctions as punitive in some respect, but there is another angle to it, which is if the U.S. wants to protect assets in some way, the blocking tool is available to the United States. But there are certain types of cases, mainly when you're dealing with state sponsors of terrorism, that are designated under a particular list where assets that are blocked under sanctions become available to plaintiffs in litigation. And the plaintiffs, in various cases, are trying to expand the reach of that rule to certain assets of, in this case, was Venezuelan state-owned entities. Venezuela is not a state sponsor of terrorism. And so through a creative theory, they were trying to get at those assets. And one of the comments that I thought the United States made, and I think you can see this in the policy with respect to the Afghan funds, is that actually we need these blocked assets to stay blocked so that we have some leverage. And it is very interesting to see that kind of come out in a public filing.
So I think non-Russia related points, I have two that I think are interesting developments. One is with respect to virtual currencies. Late last year, there was guidance put out by OFAC regarding sanctions compliance expectations for the virtual currency industry. and there was some follow-on designation actions. And it's important to note that when there are designation actions, the press releases usually highlight the behavior that they want to make sure that the private industry is on guard for and not engaging in. So there's a lot of strategic messaging in imposing those designations. I think one of the things that's interesting, and there's a Texas nexus here, is that there's a litigation that's been brought by certain users of Tornado Cash, and I'm not going to get into details because I don't understand virtual currencies at all. But from what I understand, one of the allegations here is, well, you can't designate the Tornado Cash protocol because it's not a person, it's not property, and so therefore it doesn't meet the requirements of the executive order. So there's a really interesting question here about what are these platforms or protocols, how do you categorize them, and how can you use sanctions authorities to target malign conduct occurring through those platforms or those protocols. So that's one thing that I think is interesting. I think the case is filed in the Western District of Texas, if I remember correctly. The other thing I wanted to bring up is actually very near and dear to my heart, but we've done a lot of work in the Democratic Republic of Congo. We represented, and this is all a matter of public record, we represent the 3 election officials that were sanctioned as part of their administration of the last elections, which, not to gripe, but the State Department said were successful and welcomed the results of, and that it represented the first peaceful transition of power to the opposition in the country's history. And those folks were sanctioned. That was back in 2019, early 2019, and we had been challenging their designations for a number of years. We recently, and this is all the matter of public filings in the U.S. District Court, but they recently were denied when they petitioned for removal. And one of the primary bases for the denial was foreign policy guidance provided by the State Department. And what was interesting in the foreign policy guidance is a removal of these individuals at this time would show that U.S. sanctions are short-lived and would remove a deterrent effect for the current election officials or others who might undermine the 2023 elections. In other words, we don't want to disturb anything now because there's elections coming next year. Obviously, our argument in the court is, well, it has nothing to do with us. Our clients were sanctioned for their conduct. Their conduct has been addressed by our filings, and therefore they should be removed. But this foreign policy guidance from the State Department is central to the litigation going on right now. And it also speaks to some of the earlier issues we talked about with other agencies and other components of the U.S. government getting involved in the administration of sanctions and how it weighs in on decisions from OFAC or their own actions they take.
Thanks. So we've actually talked some already about the different agencies, and we've talked about the role of Congress. And now with Nicole's comments and Eric's, we're starting to talk about the role of courts in sanctions. And Eric, I'm hoping to go back to you and then hear from others, because I really think of Eric as one of the leading people on litigating against OFAC. And so I hope that you can talk to us some about some of what you've learned about what that's like.
Sure. First, have some assets in the United States if you're going to get sanctioned, because you can at least make a good faith argument you have substantial connections for purposes of availing yourself of constitutional claims in court. OFAC is getting challenged more and more on their sanctions actions. I started suing them 10 years ago and everyone thought I was crazy. I felt in those cases, and again, we do a lot of delisting work, probably more than most firms, that we didn't really have a choice but to go to court. So what are you going to court for? What are you trying to accomplish? Really, the cases fall into a few different buckets. In some cases, it's because there has been an unreasonable delay, and for those of you familiar with the Administrative Procedure Act, what the statute says is that an agency has to deal with an issue presented to it within a reasonable time frame. Now, IEPA nor any of the other sanctions authorities set out what an appropriate time frame is. I would note, however, on the Anti-Terrorism and Effective Death Penalty Act that there's a review process every 2 years, so that's kind of a rule of thumb we've tried to use. How long does OFAC take? Well, like I said earlier, even with great facts and a client willing to do all the right things, I tell them they need to wait at least a year before we get any traction, not a decision, traction. In a recent case, I can tell you that we got a questionnaire from OFAC 4.5 years after we submitted our petition for removal. I honestly had thought, I hadn't heard from the client in a long time, I honestly thought they had just hired someone else and had gone on with their life. But no, that was the first correspondence in that case since the filing of the petition for removal. So as you can see, OFAC believes that it can take a very long time, 4.5 years, just to ask questions. And so the first category of cases that we litigate are those where we believe there's an unreasonable delay of the action. The second category is where there is some sort of constitutional claim we can make. Again, we don't do that traditionally unless we can show that the party either has some U.S. person status, physical presence in the U.S., or some substantial connections to the U.S. And what the courts have said is substantial connections can be satisfied through some showing of property interests. For example, having an office in a building in Washington, D.C. in one case was found sufficient. Having a bank account with a small amount of funds in it in another case was found sufficient. So when presented with these facts, what courts have done is not wanting to establish any kind of bright line rule. They basically said, well, we're not saying they have due process rights or not under the Constitution, but let's just assume they did. OFAC provided them all the process they were due. So the courts have kind of punted on this issue unless there's a factual allegation in the pleading that says they have no connection to the U.S. I think that happened in one litigation with Fulman Group, where the plaintiff said that, and Judge wasn't Contreras. But the D.C. District Court basically said, "Look, you admitted you don't have any connections to the U.S., and so we're dismissing the claim." The third bucket of cases where we bring action, or where we bring litigation, is those where we believe the actions are either in excess of statutory jurisdiction or the agency's action was arbitrary and capricious. Let me give you two examples of what we mean there. There's a litigation going on in the DC District Court right now. It's before Judge Walton, where we believe OFAC exceeded its statutory authority because in that case they designated a person under the Foreign Narcotics Kingpin Designation Act simultaneous with the designation of the person that was the actual kingpin that they were designating. And so our argument is that conduct or the statute only reaches the conduct of persons who are dealing with publicly identified kingpins. And if you're designating them simultaneously, that's excess of the statutory jurisdiction. Another example of the arbitrary, so putting that aside, the other example dealing with arbitrary and capricious is exactly what I was talking about in relation to the DRC election official, where OFAC is relying on guidance, with the guidance stating, well, these individuals might not be deterred if we take this person off the list. And so what courts have said is where the agency's findings are based on speculation as to what might occur rather than what has occurred, that's per se arbitrary and capricious. So I could probably talk about this for the next 3 hours. I won't. Those are some of the common issues that come up in the litigations that we've pursued.
Great, thanks, sir. Do either of you want to talk at all, either about maybe even just the pros and cons? What would you think about if a client was thinking about whether or not to sue them?
I'll defer to the litigator.
Sure. I always think it's worth looking at agency action to ensure that it is correct. And if a client is of the view that an act has been taken against them with respect to their conduct that was either misinterpreted, etc., absolutely, I would counsel challenging it, and we would look at the strengths and weaknesses of the case. As Eric mentioned, historically, courts defer to agency interpretation, and OFAC has very broad discretion. But that discretion is not unlimited, and there are guardrails that are in place for a reason. We know Exxon successfully sued OFAC, got a very favorable result on a notice issue where OFAC had failed to give sufficient notice to the public of a rule. It sounds a little similar to one of the examples that you were mentioning. Those types of checks are there for a reason, and I absolutely think that where appropriate litigation is available for a reason, it should be used.
Great. Thank you. One note that I would add is, in addition to the fact that the trend does seem to be generally towards more cases, I think in the past there had been a real reluctance among the big law firms to get involved with this. But in the Exxon case, it was Davis Polk. In the Tornado Cash case that Eric mentioned, it's Paul Weiss. I saw recently that Morgan Lewis filed a case against OFAC about a month ago. And so it seems the norms are in flux about that at the moment. So we're going to stop in about 5 minutes to take your questions for the last about 15 minutes. So please start thinking of your questions.
I think the schedule has us stopping at 5.
No, that's 5:15.
No, I have till 5.
You have till 5. Right.
So do I.
You have till 5 too?
Oh,
I was told we had an hour and a half. Okay, well, then I won't ask my last question and I'll go straight to you for questions. Please.
I was just wondering if you could touch briefly on the freezing, seizing distinction and the various proposals that have been put forward to change the. I personally think it's clear that IEPA has freezing authority only instead of seizure authority, although I know there are some who disagree. But I was wondering if you could also touch on the constitutional concerns, right, and the issues with the various proposals that have been put out to convert that to a seizing authority.
Yeah, I'll just start. I mean, the obvious distinction, I'm sure you're already aware of it, is that freezing is blocking for the pendency of the person satisfying that status of being sanctioned. Seizing is where you have some sort of violation of law which brings the property within the jurisdiction to be seized and forfeited as a byproduct of that violation. I think what's important to note here is that the standards are very different. To impose a designation on a party or to block property, what does the agency need? It needs a reasonable cause to believe, okay, which is a different standard than that used, and I'm not a forfeiture expert by any stretch of the imagination, which my colleague was here because he is, but we're dealing with a very different standard there, and I haven't really explored the arguments on both sides why IEPA would satisfy for purposes of seizure, but I think it's pretty clear from the traditional use of sanctions that blockings and seizures are two very different things. Different standards apply, and really using a blocking authority to effectuate a seizure and ultimately a forfeiture is treading into very dangerous waters.
Ben, I think you had your hand up.
Yeah, well, I'm interested sort of more broadly in the role of Congress going forward. So, because I heard two different themes. Sort of, we talked about the expansion of executive power in this area, and sort of one response is like, well, then Congress needs to get involved to pull it back. But also, every time Congress gets involved in sanctions, they tend to do it to favor some special interest in a way that further expands power. So whether it's the Helms-Burton Act or the stuff that led to the Peterson case or whatever you can imagine, or this new bill that was supposedly going to give seizure authority under IEPA, Congress is actually sort of pushing executive power. So do we want Congress more involved in overseeing sanctions, and what would that look like if we were to design some kind of oversight mechanism?
I don't know that I'm thinking of Cuba and I'm thinking of Russia, right? So I think in the Cuba context, it's been unhelpful, in my own view, to have Congress involved because it sort of tied the hands of the executive in terms of what they can do with respect to Cuba. Having said that, CAATSA, which was, enacted in 2017, to me, it appears that the real impetus of CAATSA was to be a check on President Trump, right? It was thought that, there were many speculations about Russia's influence and what actions he would take with respect to Russia when he became And so part of the drive for CATSA was really for Congress to be involved, to ensure that any sanctions relief or delistings that could occur by the power of the executive would require congressional oversight, right? Because really, I think of CATSA as a check on President Trump, and so much so that there was speculation that he wasn't going to sign the bill, and when he did sign, he said, I am signing, but it should be noted that I find this law to have a lot of unconstitutional provisions because it impinges on the executive branch's ability to have flexibility with respect to foreign policy, right? So in that case, because there was this concern about him sort of unilaterally lifting or amending Russia sanctions in a way that the U.S. government as a whole would have found to be not constructive, I thought that was Congress playing sort of a good check on the executive. So I don't know that there's a right or wrong answer. I just think that it really depends on, the stated goal with respect to the particular law.
Nicole?
Yeah, I would say trying to create some sort of congressional oversight as a general principle would not be a good idea. I think that would be kind of a disaster. I'll just reiterate. Nettie was saying the same thing. They're very different, right? Tools, right? The executive imposition of sanctions it can be lifted as quickly as it's imposed, and it is a flexible tool that gives the executive negotiating power, leverage with respect to other states, other actors, etc. When you put something on the books in legislation, it's much harder. And the battle, when we saw with CATSA, but also with other statutes, is where Congress tries to make something mandatory on the executive, but then there's some language in there that there's still a discretionary piece to it. So it's really rare that a law gets passed where the president actually has no choice but to do something. Even though the language is written in mandatory language, there's always a discretionary element. So it is a little bit of a tug of war between Congress and the executive. I think that's probably as it should stay that way. And I would not want to see some sort of congressional oversight. I think we would end up with sanctions. We would end up with permanent. We would end up with a Cuba situation in so many more instances that if you think of Libya and sanctions going up and down on Libya, there's been so many instances where the president has lifted sanctions under the case of Sudan, right? I mean, sanctions are lifted for a reason. And just on the blocking point, just to be really clear, blocking versus seizure. Blocked property is still property of the blocked person, and it is that way for a reason, right? And when the sanctions are lifted, that blocked property often goes back to the blocked person, and assuming depending on what the stage of the transaction the property was in, but by and large, it's still the property of the blocked person. So when you start treading into seizure and confiscation, and even the congressional statute TRIA that allows for state sponsors of terrorism and their property be turned over, that gets very close to you're blocking it for sanctions, but then it's getting put into a victims fund, and then it gets turned into awards for plaintiffs, all pursuant to congressional statute. So it is a very the blocking rules should stay blocking and only blocking, because again, you lose your leverage. If it all just becomes, this is now the property of the United States, that negotiating power, that leverage that the United States talked about in its brief, that goes away.
So I would just like to say one last thing in response to Ben's question, and then a closing comment. I think for Congress, it really answers it depends. At different points in time, Congress has had different goals. Sometimes the goal has been to push the president to do more or to insist that the president keep doing things. But other times you see Congress wants to liberalize. And so, for example, media, information materials trade, and also agriculture and medicine, all of that trade was forced by Congress onto the president. And so, now those may be special interests too, but they also have certain other First Amendment values and humanitarian values behind them. The last thing I will just like to say is I think something that shows how extraordinary 2022 is in the world of sanctions is how little we've talked about Iran today. So on that note, I'd like to thank the audience for coming and for the panelists for doing a great job.
Thank you.
Thank you.